And this matter is before the court today on Defendant St. Julian Westside DBA Holiday Inn's motion for summary disposition. So, counsel, why don't you place your appearances on the record?
Good afternoon, Your Honor. My name is Todd Stern. I'm proudly appearing on behalf of the plaintiff in this case.
Thank you, Mr.
And
Stern.
good afternoon, Your Honor. Nicolucci on behalf of the defendant in this case.
Very good. Thank you, Mr. Nicolucci. All right. Well, Mr. Nicolucci, it's your motion, so I will let you proceed first. And I have read your brief and also the plaintiff's response therein, where he says, this misapprehends the case. This is really a duty to warn case. More so, than the wild animal case, where, it's well established, for migratory animals, for example, or something of that nature, there isn't any liability. How can you counter that argument?
Well, thank you, Your Honor. I would just indicate to the court that I have provided two cases which deal directly with wild animals, and both of those cases deal with negligence claims. The Glav case, of course, deals with pigeons and a negligence and nuisance claims. And then, of course, I attached the TOSA case, which is an unpublished opinion. That one dealt with stray dogs chasing somebody who was then injured on the premises. The court determined that the claim for premises liability could not go forward in that case. I would just indicate to the court that from our perspective, this unfortunate occurrence happened in May of last year. And in May, in West Michigan, wild birds are everywhere, quite frankly, as they are here in mid-Michigan where I am.
Well, I do have to say this particular bird, the red-winged blackbird, is known, certainly including by me, to make dives at pedestrians. And I say that firsthand knowledge, both from running at lunchtime downtown and then near my home here in East Grand Rapids. I have had those birds actually hit me in the head because they're so desperate to drive me out of their territory during about that same time of year. And each time that's happened, I've been thankful it's not one of my kids, because it'd be enough to deter them from going outside forever. Whereas I guess I'm a hardy enough Michigan resident to just kind of expect that sort of attack to be directed at me. So yeah, I've personally experienced aggressive blackbirds as well.
All right. And then, of course, to carry the plaintiff's response to our brief even further, if there's a duty on the part of my client to warn about the existence of wild birds nesting near the hotel, wouldn't then my client also have a duty to warn of, and these are just animals I wrote down because they came to my mind. How about, because they all potentially could or have attacked humans as well. Raccoons, foxes, skunks, deer. I mean, where do we stop, quite frankly? Other than to force my client to create some sort of zoo-like situation where they have to put all these animals in cages. It's our position that the incident was unfortunate. And even though it is unfortunate, the plaintiff's claim fails because she has not met one of the required elements of a premises liability claim. I would also indicate to the court that the plaintiff has not provided any legal authority to support the arguments that she's made in this case. I certainly can answer any other questions that the court has. But otherwise, those are my arguments at this time. Thank you.
No, and I went through that, admittedly, the same exercise yesterday when I was thinking through this, and I thought, well, the horrible case that came to mind was the case where the alligator comes out of the pond at Disneyland and snatches the 4-year-old who's playing happily by the edge of the pond as their parents dine, like at the Grand Floridian's restaurant. on Disney's property, and did Disney have and I have no idea if that got litigated or I imagine it probably did, a duty to warn about such things. Don't let your uh, uh, small children frolic near the water's edge. This is Florida, and there are alligators. And I guess the thought that came to mind was, well, that depends. If you saw the alligator sunning itself out there every day and maybe snatching, other small creatures from the edge of the water, that makes a stronger case on duty to warn. And if there'd not been an alligator in that little corner of the pond for 20 years, there might be a different story. Is it a case by case analysis, or is it just a broad brush? Wild animals do what wild animals do, and there's no liability.
Your Honor, I believe it's the second, and I only say that because in the legal research that I did and that was also undertaken by the paralegal assisting me, these are the cases I could find and we could find regarding wild animals and the duty to any sort of duty that arises from the actions of these wild animals.
Okay, and of course, the underlying premise there is the animals themselves are totally unpredictable, and that if we undertake to um, warn even about the ones we know about being in the vicinity of our premises, uh, it's a fool's errand, because the next thing that might happen, right, as you point out, would be a snapping turtle waddling up from the Grand River and biting someone on the ankle or something. And how can you predict such things when these are wild animals? So, well, let me throw it to plaintiff's court.
Thank you very much, Your Honor. Well, you've hit the nail right on the head. You've identified the issue in the case right off the bat, and that is under Bertrand versus Allen Ford. And so let me just say, Mr. Nicolucci says we didn't cite any case law. Well, I disagree with that premise. The two cases that kind of control the law these days, Candle El Sayed and Bertrand versus Allen Ford, very clearly say that an invitee has a duty to their invitees to exercise reasonable care to protect invitees from unreasonable risks of harm, including a failure to warn of a hazardous condition or a duty to warn of a hazardous condition. What's unlike the cases that Mr. Nicolucci mentions, where it could be a dog or a skunk or a raccoon or these other animals, is that, and unlike the analogy you made, Your Honor, this is a predictable situation. We're not talking about stray dogs in the area that attack the plaintiff or some skunk that wanders out of a bush. We're talking about a situation where the hotel knows that these birds are nesting immediately adjacent to the front door of their property, so much so that they've ordered signs to put up. They just haven't put the signs up yet. They just hadn't received the signs to put up yet. But they knew that these birds were a problem. These birds are predictable. They have been becoming protective of nesting areas, and this was a nesting area immediately next to the front door of the hotel. So again, this is a duty to warn, and it's a failure to warn of a known problem that they've got. So this would be analogous in my mind to a low-lying area on the cement next to the front door that collects water and maybe freezes in the wintertime. Mr. Nicolucci in that case, I'm sure, would say it's an act of God. We can't control the rain. We can't control what happens with the rain. Well, guess what? They can control a depression on their cement that allows water to collect and freeze. And that's what we have here. They know of these dangerous birds. According to the expert that we've hired, we have a report attached as exhibit number 4, Your Honor. There were a number of things that the hotel could have done that would have made a big difference. A warning sign being an effective tool, number 1. They could have used some kind of netting around that front door to prevent birds from swooping into their customers in the area. There were a couple of other things that they mentioned. I attached some pictures from some other local businesses that are using signs to warn their patrons. So it's not something that's not being done. So I believe that this case fits squarely within Bertrand and Candle El Sayed, and it's just an overreach to say you can never sue anybody for a wild animal about anything ever. I mean, I think that is just much too much of a broad brushstroke, and it does have to be taken on a case-by-case basis, as you said. This happens to be one of those few cases that should squeeze by because the defendant knew there was a problem and did absolutely nothing about it.
All right. Well, and those factors that I kind of ticked off that the defendant would have some control over. I guess this is going back to you, Mr. Nicolucci, would include they allow the bushes that are apparently attractive for nesting for the blackbirds next to their door. They do utilize the door. And apparently on this day without any warning signs. And then finally, of course, the parking lot's also proximate there, so a person is kind of constrained as to where they can walk. They have to walk past the bushes and said blackbirds to get to the door. I think what you're trying to say is, Judge, those all may be true, but they don't make any difference simply under what I'm going to refer to as the wild animal doctrine here.
I concur, Your Honor. Well said.
Okay. All right. Well, very good. Well, in this particular case, the plaintiff was, as has happened to me and doubtless many others in this area, assailed by the red-winged blackbird in the springtime that was defending its nesting area. And the question is can the Holiday Inn, which under the facts before the court, knew that blackbirds were, of course, present in the area, their employees and guests having dealt with them in the past, had put out signs in the past warning people of the possibility of swooping birds, and further maintained, as I said, there were bushes outside the Holiday Inn, and those bushes were of the sort where the blackbirds may nest. So creating, in other words, an environment hospitable to the blackbirds. And I was thinking as I heard the arguments here, why don't we have those signs outside the courthouse? And that answer may be as simple as, well, I believe we only allow one tree to grow outside the courthouse. Of course, our security folks maintain a pretty close cropped lawn in the area outside the courthouse, and there are a lot of cement and steps, and it probably is not very aesthetically pleasing because we don't have any bushes or trees, but probably also not very attractive to red-winged blackbirds. And I will note that every time I have been assailed by one, it's been in some area that has, bushes or growth like that present. And so I do think that is a factor, and plaintiff has identified that by attaching their expert report. And I'd have to agree in the case here, it would be too broad a brush to paint such a situation as well. Anytime we have a accident where the causative agent is a wild animal, that couldn't possibly be an occasion for premises liability vis-a-vis an invitee, of course, who has the highest level of protection. After all, this isn't a burglar or even a person on the premises for other purposes. They're a person making a food delivery. Undoubtedly, food deliveries support not only the employees but the guests of the Holiday Inn, and are encouraged, therefore, to make use of that space along with guests and employees. So, and this person comes in, and most West Michigan residents might be aware of the proclivity, but of course, of these birds to attack, but the warning sign in this instance might have put that person on notice to perhaps cover their head up or at least look above and not be as surprised and, occasion the fast running acceleration start that often precedes a hamstring injury that this judge has also encountered in the past during a softball practice. Despite trying to stretch and things like that, I learned that it's never a good idea to move too fast from a stopped position. So, the difference here, at least from two cases were presented by the defendants, urging the court to grant this motion. The first one being the migratory birds case, the only other bird case. Let's see here, and that's the Glaive case, which is a Mishap case, Glaive v. Michigan Terminix Company, 159 Mishap 537. In that instance, the city hired the contractor to come in and treat certain areas which had the effect of displacing pigeons. Now, in that case, of course, though it would be predictable that the pigeons would roost somewhere, where they chose to roost would be totally unpredictable. That is, the city, no one else could have foreseen, the fact that these pigeons would roost in the plaintiff's home and cause some sort of mold infestation or allergy to take root there. So in that case, you didn't have the factors of foreseeability of the harm that might occur. And secondarily, there is the stray dog case. I'm not as familiar with it, but obviously in that case, it would be a different story if the business fed and encouraged and perhaps even provided a little dog house for the stray dog, and the dog lived on the premises and then came out and attacked someone. We all know in that circumstance, a homeowner or property owner could be liable for the dog because they're exerting some degree of control over the dog. Whereas the really stray dog that just wanders onto the premises, the proverbial lone wolf out there, straying across parking lots, who decides to attack someone in your particular parking lot, well, there again, you can't have liability. And I would say that this case is somewhat closer to the other circumstances that I identified, where the Holiday Inn, probably unintentionally, certainly unintentionally, provides these bushes, although they are part of its landscape plan and part of the aesthetic of the building. There are, with certainty, these bushes that are potential nesting grounds for blackbirds. The blackbirds are known to be territorial, and that a known risk of having those blackbirds. And could you solve that problem by tearing out said bushes and putting down an unattractive patio or sea of little golf ball sized pebbles? Well, you probably could, and I hope that I don't push the Holiday Inn in the direction of doing that. But such is the unintended consequence sometimes of legal liability. But nonetheless, there are bushes present, and the bushes are proximate. Everyone agrees to the front door of the Holiday Inn in this instance, in that a person walking in the front door of the Holiday Inn would be close enough to a bird nesting in those bushes to spark that territorial defense reaction from the bird, and perhaps then be assailed by a blackbird. And it was so known that, as I said before, the hotel had, at least allegedly on occasion, put out signs in the past warning about blackbird attacks. And in fact, there are other businesses that put out signs giving those warnings. Now, again, the warnings are undoubtedly more effective for the people than they are for the blackbirds. I'm sure the blackbirds are never deterred by the signs from attacking people, but at least you get a little bit of a heads up that perhaps this aerial strafing is likely to occur during particular months of the year here in West Michigan. So I do believe that those combination of factors, that is the location of the door, the location of the bushes, and the known tendency of the blackbirds to nest in the bushes and be territorial in defense of their nesting grounds, distinguish this case from the other cases that were cited by the defendant's brief, and bring it within a case where there is a fact question, at least, as to whether or not the Holiday Inn had a duty to warn this particular patron that she might be attacked by blackbirds. So I will deny the motion for summary judgment for that basis at this time. Mr. Stearns, will you send me a proposed order?
Yes, Your Honor. I will make sure that happens before the end of the day.
Very good. Thank you, gentlemen. It was very well briefed, and at least made for some interesting reading. It wasn't the standard no fault automobile case.
Thank
All
you,
right,
Judge.
thank you
Have a
very
great
much.
week.